record on case number 23 CB 4944, Lana Oriani and versus Vanessa Walsh. Miss Walsh, I believe, is a Colorado resident, so she is appearing via Zoom link this morning. Miss Walsh, can you hear me okay?
Yes, Your Honor.
Okay, all right, so the parties are present in the courtroom. We are scheduled today for an evidentiary hearing on Miss Oriani's petition seeking a protection order to be issued against Miss Walsh. Miss Oriani, are you ready to proceed this morning?
Yes, I am, Your Honor. Can I just finish playing this one?
Okay.
Thank you.
Miss Walsh, are you ready to proceed this morning?
No, Your Honor, I'm not. I'd like to address a few short things with the court.
Okay. Go ahead.
Okay. I do not believe that I was properly served. I'm not real clear why Ms. Oriani sent this to my lawyer's office. When I look at the complaint, it says that it's supposed to serve me at home unless she doesn't know that address. As I'm sure the court remembers, we had another hearing back on January 10th, 2023, and she did serve me at home for that one. She does know my home address, but I am here today because I didn't want a default judgment to be entered without me knowing.
But to be clear, you're still asserting the defense of insufficiency of process? So your presence today, because some people just go ahead and waive service, you're not doing that, is what you're saying? That you're claiming you weren't properly served, and so you're appearing today to put that defense on the record. I just want to make sure.
Correct.
Okay, thank you. Go on.
I can wait. I mean, I am waiving service too, but I'm just explaining why I'm here.
Oh, you are?
But,
okay. Sorry.
Yes.
Okay.
No, that's okay. Sorry, I might not have explained that well enough, but let me get the complaint here. So let me pull it up. All right, so I just want to address a couple of short things and ask the court to dismiss this complaint because it is the same subject matter that we met here before for the first hearing. Also, as it was decided last time, this court does not have personal jurisdiction over me. I think that the court could take judicial notice of the complaint that Ms. Oriani filed back on October 18th, 2022 in case number 22 CB 7251 and this one that was filed on July 13th. This complaint and the prior one in January are about the same issues. Ms. Oriani has already litigated these things and she lost. She's just trying to relitigate them all over again. This is an abuse of the system, a waste of time and resources, and it's just taking a second bite of the apple. The court already ruled that she lost on the merits of her first complaint and also that the court lacked personal jurisdiction over me. Filing this CPO shows that, in my opinion, Ms. Oriani has a lack of respect for the court and the previous findings. In the first petition, she says a bunch of things that includes me using third parties to hurt her. She says the gist of it is that I directed third parties to cause her mental distress. She says, she complains that I sent a process server to her home. In the new petition from July 13th, she makes the same allegations. Actually, I wanted to point out that above paragraph 1, in quotes, she has, quote, can prove now, end quote. So that right there is an admission that this has already been litigated. And then again, after paragraph 11, she literally says that she wants a hearing to, quote, prove allegations based on case law from last time, and I can now show the connection between Vanessa and all third parties, end quote. So right there, she's acknowledging that this is the same subject matter. So there are rules on relitigating things that have already been decided on the merits. A 1995 Ohio Supreme Court case called Grava versus Parkman with a citation of 653 Northeast 2nd 226. Let me pull that up. Says that a valid final judgment rendered upon the merits bars all subsequent actions based on any claim arising out of the transaction or occurrence that was the subject matter of the previous action. So this court's already ruled on all of these issues. The court specifically found that she lost on the merits. The judgment was final because it wasn't appealed. And there was a ruling on the merits, and the court also found that based on our 10-hour January hearing, that the court could not exercise personal jurisdiction over me. So I'm respectfully requesting that the court dismiss this case today based on the other case and this court's written order dated January 24th, 2023 in case number 22 CB 7251.
Okay, thank you. All right, so a couple things before I let you respond, Ms. Oriani. What I'm hearing Ms. Walsh say is that even though she does not believe she was properly served, she has chosen to appear and she's going to waive any defense of insufficiency of process. The personal jurisdiction argument, unfortunately, I have to use circular logic because there is case law that says if somebody has committed acts that amount to what's called menacing by stalking, then that's directed to an Ohio resident, then this court would have jurisdiction over them. And just like last time, unfortunately, I just had to have a hearing on whether there were such acts before I could determine if I had personal jurisdiction. So, you know, the two issues become conflated. So, what I want you to address, Ms. Oriani, is Ms. Walsh's assertion of what, you know, we call the defense of res judicata. She's saying that these issues have already been litigated and have been ruled on. There's been a final order that wasn't appealed, and therefore you are barred from, as she put it, taking a second bite of the apple and just relitigating something that's already been adjudicated. Do you have a response to that argument, please?
Yes. As far as that argument goes, I wrote in the complaint that there's new evidence that shows other acts of the menacing by stalking, with me being able to connect Miss Walsh to these people that I did not have before, that I did not know before. Miss Walsh also then took it upon herself to refile and try to get a contempt citation motion yet again to have me arrested, hauled into Colorado, and that was actually filed with her lawyer on June 26th. In Colorado. Let me pull this up. June 26, 2023. Colorado denied the motion proposed. Her lawyer never even sent me the motion. I had to find out a different avenue. And in it, it says that the courts find no violation in these actions that would support a contempt of court citation. This protection order does not prevent defendant from pursuing a legal claim of action against plaintiff or the attempted service of the action. And that's what they were trying to, yet again, harass me with, and they issued another motion to try to get me again picked up to be extradited, and then they wanted me they want jail time. Again, I put on my motion or my petition that there was new evidence, new witness that links Miss Walsh directly to the acts, and we need to have that hearing here today to see if that
Links her to the acts
of menacing by stalking.
that you were trying to prove last time, but now you have a new witness.
I have a new witness, but additional.
What new acts other than the June filing?
There's the June filing, and then her admissions of how everything went down with I never had her on the stand, so we didn't get to address anything that has to do with the first citation motion. Never got addressed. I never got to have her on the stand. I chose not to, based on me not knowing. I did not want to get in any type of trouble, so therefore things were not brought up at that hearing that were supposed to. in addition to what has been uncovered new.
But I'm specifically asking uncovered new, the decision was issued in January.
Mm-hmm.
The hearing was in January, correct?
Yes.
Okay.
Yeah.
So what new acts have happened since January? You told me about this June filing. Have there been other new acts that you want to talk about?
Yes.
What are they?
So there is a woman here that's set to testify. Her name is Amber Forte. And she's testifying on Miss Walsh telling her and waiving her client attorney privilege with giving her information that her lawyer gave her on how they were going about stuff with her lawyer, saying that I was contacting her and her lawyer multiple times a day. That she was being contacted that I was a coke addict, that I poisoned her dog again. She used her YouTube channel to put this stuff out on the internet.
When?
Beginning in June of 2022 to present day. She blocked them. Again, the service with my son never got addressed because she never took the stand. And that she is saying that she's working to have my child taken from my custody. And that's continuing.
Your Honor, am I allowed to respond?
Give me 1 second, of course. Are you done? Anything else, Ms. Oriani?
It's a pattern of behavior. So this is different acts, and it's a repetitive pattern, and that's menacing by stalking. That's what the definition here is. And why I didn't have personal jurisdiction last time is because I couldn't prove any damages that she had done. This time I can prove, as an Ohio resident, I was damaged with her actions outside of the long arm statute, which it reaches.
Okay. Ms. Walsh?
Your Honor, the only pattern that's been established is ever since I've received, that I was awarded the restraining order in Colorado, she has been trying to get revenge for it and has been dragging me through the court system while simultaneously breaking the restraining order and continuously stalking me. She just gave you an example by contacting people that have spoken to me. She's not supposed to be doing that with the restraining order, contacting people I've spoken to and obtaining private conversations that are supposed to be private between two people, that the only interaction that Ms. Oriani and I have is in this courtroom when she drags me to court. And if she does have a problem with something and she thinks there's something that should be litigated, she should be doing it in Broomfield County, where the evidence has been heard, where this has already been litigated, and where she willingly availed herself to their jurisdiction.
Okay.
You can hear when she's speaking to you, she's grasping for straws, trying to come up with stuff that's new. She just gave 3 examples that I heard specifically of things that we already litigated prior. She just admitted it's to get me on the stand because she didn't do it last time. That's unfortunate for her, but things turned out the way they did. She also wanted to redo the restraining order hearing in Colorado, lost that appeal. It's not right to abuse the system in this way, to punish me for getting a restraining order when that judge found she was a credible threat to my life and the life of my family. And she's already put me through enough the past 2 years. I find this a blatant abuse of the system.
Thank you. All right.
Can I respond to that?
Just real quickly, okay?
Okay.
We're not going to keep going back and forth all day.
Yeah,
All right? Because
Yeah, really quickly, is that things haven't been litigated in Colorado. I'm here on new issues, and there is no, if Ms. Walsh wants to testify to things that have gone on, that's an opportunity to testify. What Ms. Walsh is doing is she is speculating, she is inserting herself with what she deems she thinks. The reason that anything was issued in Broomfield is because they found her a credible witness. I have the findings here today. That was not something that was put in evidence or brought up at our last hearing, that they found her a credible witness. I am here today to show that Ms. Walsh is not only a not credible witness, but that she has been doing this to me back then and continues to do it daily.
thank you. All right. I'm just trying to gather my thoughts. Bear with me. Okay. At the end of the day, you're not disputing there was a hearing, the 2022-7251 decision got issued. The decision was adverse to you. You've never appealed it, correct?
No, I did not appeal that.
Okay, so that is a final ruling under the law because you never took an
Correct.
appeal. Okay, all right, I just want to make sure that was on the record. Okay,
Yeah, Your Honor, I'm here for new allegations.
I understand. the defense of race judicata, and like I said, I'm saying this on the fly. I'm going to put everything in writing, so I can't think of everything that needs to be said right now. But my initial ruling is that Ms. Walsh has properly asserted the defense of race judicata, and it would apply to bar these claims. The way the defense works, it's not just what was actually litigated, it's also what could have been brought and litigated. Now, you're saying you just discovered new evidence, but you had a duty when you brought your case the last time to fully investigate your claims, bring all the evidence and witnesses, documents, everything at that time, presented at that time. We can't just keep this being an evolving process. Every time you learn something new, okay, well, we're going to reactivate it, because there are ways to reopen cases properly, but what you don't get to do is just file new lawsuits saying, hey, I've got better evidence, better witness testimony I didn't know about at the time, so I'm just going to refile. That's just not how the law works, okay? Most of what you wrote in the petition basically made the case for the defense of res judicata, because you're saying, I've got evidence now, I can link it now. So I do find this subsequent refiling is barred by the doctrine of res judicata. I was careful to ask you what new things you have,
Yes, Sharon, can I speak on
because
that?
it would not apply to new conduct. What I haven't heard is that Ms. Walsh is starting to reach out to you. And one thing I will say, Ms. Oriani, is I understand the law is confusing. The law, especially the Ohio statute, is written very broadly as to what menacing by stalking is. But that's why we use case law to fill in the blanks and to make sure that we're properly applying it. It's not just a general anti-harassment statute. You don't just get a protection order just proving that, hey, somebody's engaging in conduct that's causing me mental distress, okay? Menacing has a specific meaning under the law. There's free speech rights. What I'm hearing you say is that you know she's talking about you, she's making accusations about you, putting that on the internet, but she's not tagging you, she's not, calling you up saying these things directly. If this is a no contact order, if she's saying things on YouTube that you consider defamation and slander, then you have to file actions for that. You can't use this as a substitute for civil remedies. If she's talking to other people, acting in concert with other people, that may be in a civil conspiracy claim, intentional interference, but what she's not doing is directly, contacting you, bothering you in your face every day, nonstop. That's what this order is designed to prevent. Not that people behind the scenes are doing things that you consider harassing, ruining your life. We can't use this order just to prevent all bad conduct, okay? That's just not what the purpose of this is.
Yeah, I understand that, Your Honor, and what the purpose of this is that this is repetitive behavior. This is one incident alone is not sufficient to establish a pattern of conduct. I am showing, what I will be doing here today is showing a pattern of conduct that after we were here in July of 2023, this stuff didn't stop. It escalated. Right. This is contacting
because she has no order against her. She's allowed to call people up and talk about you, and now if that violates some other civil tort, then you may be able to file that. But what the kind of conduct that you're telling me is not a menacing by stalking.
She's distressing
action.
me.
I know, and I just told you that people do things all the time that cause distress. I mean, my daughter, I nag her every day, and she just told me the other day, your nonstop questions are causing me anxiety. Under your definition, that means my daughter can come in and get a restraining order against me because I asked her, did you clean your room today? Did you contact the school? Did you do that? Because, yeah, I am stressing my daughter out.
I can show that.
But that's not everything is a stalking situation. That's the part that you're missing, is that this is to prevent menacing by stalking when somebody's constantly contacting you.
This
And-
person that's here to testify is here to testify that that's what she was doing to me because of her. So she was like, I was engaging in this. I was doing it for her. And I was like, well, that's third party. That's what that is. And this was after the fact. This is them reaching out in April of 2023. This is all the things after January. And she's here today to testify to what has gone on after that.
But this
And that they reached out to her.
If this lady chose to stalk you and menace you because of things that Miss Walsh said, then shame on her, okay? But Miss Walsh isn't the one. You haven't shown, just like last time, that
Yep.
she's engaging you. It's the same conduct as last time. She was talking to other people. They said they want to report your YouTube channel. They talked about talking to your ex-wife's attorney. Yes.
I couldn't link that they were doing it at her request last time. I can link that this time.
Listen, she has no orders against her. So
I know I'm trying to get an order so that she can't do that. That's what I'm here to do.
and that's more of a civil conspiracy claim.
I thought
Okay, she's got free speech rights.
I thought it was third party you cannot ask a
That's
third party.
if you prove somebody's a stalker and they're directly contacting you, then the court can say knock it off and don't try to do an end around by having somebody else contact on your behalf. But we're not there yet because she's not even contacting you. She's talking about you behind your back.
She's having other people contact me for my whereabouts. That's what
And
this
we
is.
talked about this. You had a hearing the last time, and you didn't prevail. And
And that's why I'm here to try to prevail. And the way that I can do that is by having my witness, myself, and Miss Walsh on the stand to show what has taken place. I can't do that, and you're supposed to take this at prima facie, so you're supposed to take it at, these are new allegations. I have an opportunity to have an evidentiary hearing.
new allegations, but it's based on the same type of conduct where you're saying that she's acting in concert with other people, and then those other people are now doing things to you. That's what was decided last time as well, okay? So I'm gonna, what I do is make a written recommendation. The case is assigned to Judge Perlaza. He'll review my findings. He can accept them, modify them, or reject them. If he rejects it, then we'll reschedule the case for a hearing, okay? But that's going to be my ruling, but I have to put that in writing. Both of you will get copies of the court's final decision in the mail, okay? Anything that you need to put on the record, Ms. Walsh, before I let you go?
No, just thank you, Your Honor.
Okay, all right, you're welcome. Ms. Oriani, I know you've got other cases set today. I've got to figure out what's going on with my other docket, and then I'll let you know what time those other cases will start, okay? And Ms. Walsh, you're excused. I'm gonna close the record. Thank you.